Well, good afternoon, everybody. Thank you very much for making time in what I'm sure is a busy day to join us for this webinar on tips and tricks in the administrative court, which is certainly an enticing sounding title. When I started in the days before they'd invented this thing called the internet, there were two things that were vital sources of tips and tricks. There were little skinny books. One had the key information about how to get to the court from the train station, thereby avoiding blowing part of your brief fee on a £5 taxi fare. And the other, which was even more useful for tips and tricks, was about where to stand in which court, what to call a judge. Magistrates are not called, your worship. Who went first, and most importantly, whether you should wear your wig. And I confess, I think I got all of those things wrong at least once in the early days of my career. But here today, we have much more elevated topics, and indeed very talented and knowledgeable juniors to talk about them. Imogen is going to go first, and she is going to talk about the no substantial difference test for permission and relief. Then Will is going to talk about procedural rigour in administrative law, something which I think we all have to accept the old days of it doesn't matter, it's the administrative court really have gone. And then thirdly, and finally, Azim is going to talk about costs in judicial review. He's concerned it's boring. It's not. It's interesting and it's important. As well as being interesting, our side of the bargain is we're going to try very hard to stick to time. That means my colleagues each have 12 minutes. And they will put some slides up, which will be available on our website later. And I think what we'll do is keep any questions or comments to the end. But if you do have any, please post them in the Q&A and we will deal with them if at all possible. So with that, I'm going to hand over to Imogen, who's going to talk about no substantial difference.
Thank you, Tim, and hello, everyone. The so-called no substantial difference test has just celebrated its 6th birthday. 6 years of the test being the scourge of every claimant public lawyer's life, whilst becoming a good friend to those representing defendants. So what have we learned in those 6 years? At this point, I'm going to share my screen and hope that you can see my PowerPoint. Hopefully you can now see it. I'm getting nods. The test is found in section 31 of the Senior Courts Act 1981, having been inserted there by section 84 of the Criminal Justice and Courts Act 2015. First, a brief history of the test. In the world before the new section 31, the threshold for materiality in JR was governed by the common law. The position from cases like Simplex was that the court would grant relief unless it was shown that the decision would necessarily or inevitably have been the same. The test stemmed from 2013 JR reforms spearheaded by Chris Grayling, then Lord Chancellor, who stated in an infamous Daily Mail article that he wanted to ensure JR was not, quote, a promotional tool for countless left-wing campaigners. Grayling wanted to stop, quote, unmeritorious claims, Freudian slip. But the reforms went further than this by introducing the test, which did two things, even for claims with merit. First of all, the test brings forward consideration of materiality to the permission stage. And secondly, it lowers the threshold for refusing relief. So let's remind ourselves of the wording of the test. First of all, in subsection 2A, with apologies for the dense text on this slide, we can see that this provision mandates the High Court to refuse to grant relief in certain circumstances, or to make an award under subsection 4. That's the power to award damages, restitution, etc. Now, subsection 2A is a departure from the usual position in JR, which is described in Fordham's Judicial Review Handbook as, quote, a first principle of judicial review that remedies are discretionary. That's at 24.3. This statutory provision means that relief must be refused when it appears to the court to be highly likely that the outcome for the applicant would not have been substantially different if the conduct complained of had not occurred. Let's take a look at the wording of the sister provision. This is found in subsection 3C onwards. This time the test is applied not to the grant of relief, but at the permission stage. We see the court is permitted to consider the test of its own motion, but it's mandated to do so if a defendant asks it to. So this points to an obvious tip for defendant lawyers. Raise your no substantial difference arguments in your summary grounds of resistance, or else you have no guarantee that the court will consider the test. This in turn leads to a point for claimant lawyers. If a Section 31 argument is raised against you in the summary grounds, responding to that would seem a good justification for filing a reply. Now, whether and in what circumstances to lodge a reply seems to be a perennially contentious issue in JR, since at least for the time being, claimants cannot do so as of right. And of course, it's important that replies must be genuinely responsive rather than just an excuse for rehearsing arguments from the statement of facts and grounds. But if you're pleading why the conduct complained of did make a substantial difference, that would seem to me a paradigm type of point that would justify a reply. There's a further opportunity for claimants baked into the statutory scheme. We can see that in subsection 2b, the court has a discretion to disregard the test if it considers that it's appropriate to do so for reasons of exceptional public interest. So to give you a flavour of when that might be used, in the Plan B Earth litigation, the Court of Appeal accepted that there were reasons of exceptional public interest. And in that case, those were climate change, which was described as, quote, a matter of profound national and international importance, of great concern to the public and indeed to the government. I should just signpost that the Court of Appeal judgment was reversed by the Supreme Court, but without returning to the issue of Section 31. And for now, this remains the key example of the appellate courts accepting an exceptional public interest. So has the test proved to be the thorn in claimant lawyers' sides that it was intended to be? Well, that view does seem supported by Lord Justice Coulson's approach when he gave the judgment of the Court of Appeal in Gathercole and Suffolk County Council. This was a case where Section 31(2)(a) was held to apply to a breach of the public sector equality duty, or I'll also call it PSED. Lord Justice Coulson stressed that it's important that a court does not shirk the obligation imposed by Section 31(2)(a), and that where quashing the decision would be a waste of time and public money, the application for JR should be rejected to ensure that JR remains flexible and realistic. But there are some important lifelines thrown from the bench to claimants too, such as that from Lord Justice Sales, as he then was, in the PCSU case, where he stressed that although the test had lowered the threshold for the refusal of relief, the threshold remains a high one. So which factors are going to determine which of these two directions the court will go in? Well, the case law indicates that the type and the quality of the evidence is going to be a strongly determining factor. Applying the no substantial difference test, the court must undertake its own objective assessment of the decision-making process and what its result would have been in the counterfactual absent the unlawful conduct. And the evidence before the court will be key in shaping that objective assessment. So I'm going to compare some recent cases with contrasting outcomes. Let's stick for the moment with Lord Justice Sales in PCSU. This was a failure properly to consult challenge. The defendant filed a witness statement supporting the argument that even had the relevant body been consulted, it would have made no substantial difference. The defendant was not successful in its deployment of the NSD test. Lord Justice Sales found that the witness, who did not have first-hand knowledge of the taking of the decision, had engaged in an exercise in speculation about the counterfactual. He said that self-interested speculations of this kind by an official of the public authority should be approached with a degree of skepticism by the court. Also in this case, there were gaps in the contemporaneous evidence, which meant the court hadn't been placed in a position where it could make a critical evaluation of the assertions in the witness statement and satisfy itself that they were justified. Another warning to defendants this is the case of John Harvey and Mendip District Council. This time it's a cautionary tale about the danger of adducing no witness evidence that the decision would have been the same in the counterfactual. Again, this is Lord Justice Sales giving the judgment of the court. And at 47, he said, although a court will be appropriately careful in reviewing evidence produced by a decision maker long after the decision, and will evaluate it carefully in light of the contemporaneous materials, it is nonetheless telling that none of the decision makers in this case have felt able to put before the court any witness statement to support the contention that they would have reached the same decision. So two potentially helpful precedents for claimants there, should you find the evidence in your case, or the lack of it, resembles that in those two preceding cases. Contrast this with the position in the Durand Education Trust case. This case involved an alleged failure to comply with the public sector equality duty. The Court of Appeal accepted the defendant's argument that compliance with the duty wouldn't have altered the decision. So what had the defendant done in this case that was different? Well, once the breach came to light, the defendant carried out an equality impact assessment, albeit an ex post facto one, which supported the argument that earlier consideration would have made no difference. The defendant apologised for the breach at trial, and the defendant filed witness evidence from the original decision maker, who, it's recorded at 73, acknowledged that it was difficult to put herself back in the position she'd been in, but, quote, having tried to exclude any element of prejudgment and to consider matters afresh, she concluded her decision would not have been any different. Lord Justice Newey, giving the judgment of the court, concluded at 76 that this witness's assessment was wholly convincing. The fact that the ground of the challenge was a breach of the public sector equality duties seems also to have assisted the defendant here. In Gathercole and Suffolk, that's the third bullet point, and we also looked at it on an earlier slide, the Court of Appeal described a breach of the PSED as, quote, a good example of the type of situation for which Section 31(2)A was designed. I'm going to end on a case offering a little hope to claimants as well as defendants, and that's the Forward and Aldwick case. This was also a breach of PSED, but this time it was raised by way of a defence to a possession claim rather than as a ground of JR. But the breach was found to have made no substantial difference. The court noted that this was a case where just one individual was affected by the decision. So the court was in a relatively stronger position to assess the consequences of the breach of duty than it would be in a challenge affecting more people. So far, so good for defendants. But the Court of Appeal also dropped some helpful obiter breadcrumbs for claimants. In finding that there was no substantial difference on the facts of the case, Lord Justice Longmore left the door open expressly at paragraph 22 for major governmental decisions affecting numerous people to be quashed on the basis of non-compliance with PSED, since the defendant is going to find it much harder to establish for that much larger number of people that the breach made no substantial difference. I'm aware of the time, so to sum up, gleaning the lessons from the case law, for defendants, the advice seems to be to fix the gaps in decision-making, even ex post facto where possible. Raise your no substantial different arguments at the permission stage, preferably accompanied by evidence, both contemporaneous and a witness statement from the primary decision maker. For claimants, it's challenge your Section 31 arguments in a reply, capitalise where the original decision maker has given no evidence on the other side, remind the court in all cases of the need for due caution when approaching ex post facto evidence, and remember the exceptional public interest provision. I've reached the end of my time, so I'll now pass back to Tim. Thank you, Tim.
Thank you very much, Imogen. That was extremely interesting. There is a dilemma here for defendants, isn't there? It's obviously right that you need evidence in many cases to make good this kind of defence. But of course, there is generally a rule against ex post facto evidence in JR, cases like Ermakov and a long line of other cases. So, and it can be particularly difficult to come up with an ex post facto defence if the argument is lack of procedural fairness. Well, if we had consulted, it would have made no difference. It's not very attractive when the whole point of consultation is to hear people's views. So it's interesting that this is a fault line in the case law. Thank you very much for that. Now, Will is going to talk about procedural rigour in a more general sense.
Thank you, Tim. Just sharing my screen. So the reason that I want to talk about procedural rigour today is as a judicial assistant in the admin court last year, this was something that came up time and time again, and it was a really hot topic amongst the judges. And there's a real push by the admin court to dispel any notion that the rules don't matter in public law proceedings. And nowhere is this set out more clearly than in the preface to the latest iteration of the admin court guide. And you can see the extract on screen. Slides will be available afterwards, so don't worry if you can't take it all in one go. But in particular, I'd highlight the last few sentences. The fact that conduct of litigation in accordance with the rules is important for not only the overriding objective, but also this wider public interest in the fair and the efficient disposal of claims. And then you have a rather ominous parties may be subject to sanctions if they fail to comply. Now, what I want to do in this talk is do two things. Firstly, to set out what, in my view, are the two key authorities when it comes to procedural rigour. And these are the two cases which both claimants and defendants are going to want to have at their fingertips when the other party or they are in breach, and also which the admin court will have at the forefront of its mind. And then consider some examples of both a very robust approach being taken, but also instances where the admin court has given parties a bit more leeway, has adopted a more flexible approach. So the first key authority is AB and Chief Constable of Hampshire, and this is the case referred to in the admin court guide. This was a strongly constituted divisional court, PQB, and Mr. Justice, now Lord Justice Lewis. And in response to various procedural breaches by the claimant, they said this at paragraph 108, again, echoing what is said in the admin court guide. And what I want to emphasize, for reasons I'll come on to very quickly, is the penultimate sentence. Public law cases do not fall into an exceptional category in any of these respects. And the reason that I want to highlight that is to compare it to the next key authority, which is central to procedural rigour and these overarching principles. And that is a Court of Appeal case called Talpada, which many of you may already be familiar with. Now, the extracts I've got up on screen are from Lord Justice Singh's judgment in that case. And what he emphasised at the beginning of paragraph 67 was the real importance of procedural rigour in public law proceedings. He then went on at paragraph 68 and 69 to criticise a common occurrence where grounds of appeal, grounds of review, arguments evolve over the course of proceedings and go beyond the points which are set out in the pleadings and in respect of which permission has been granted. He also, and this is the bit that I think provides a useful and interesting comparison with AB and Chief Constable, sought to recognise that public law litigation, yes, the rules do matter, but it is still slightly different to ordinary party-to-party litigation. And that's recognised in the underlying sections because of these wider public interest factors, which are unique to judicial review proceedings. Now, I think there is a bit of a tension here between Talpada and AB. And why is that relevant? Well, firstly, it would indicate that the admin court guide perhaps sets out a more strict approach than is in fact enforced in reality by the admin court. And I think there's also a practical point here, which is that if you are a party in breach, you might want to try and rely more on Talpada, whereas if you're the party on the other side, you might want to emphasize more the point about non-exceptionality of public law proceedings contained in AB. So those are the two key authorities. So what are some examples of the court trying to enforce and uphold procedural rigour? There are various examples I could have relied on here, but I've gone for two. The first is the Tapowder type situation where you've got arguments, grounds of review expanding, changing over the course of proceedings. And here are various recent cases where that kind of approach to public law litigation has been criticised by the admin courts. Now, obviously don't have time to go through all of these cases, but I do think there are three broad points you can draw out from these authorities. The first is that if a claimant wants to rely on fresh arguments, they are going to have to rely on CPR 54.15, which provides that the claimant has to make an application to rely on fresh arguments. And as the Dalton judgment, which is the third one on the list, as that makes clear, these rules also apply in the most urgent of cases. So the rules have to be, or the admin court are enforcing the rules in all types of proceedings. And the second point, following on from this, is that if a claimant fails to make their CPR 54.15 application, well, then the admin court is fully entitled to disregard those arguments if the interests of justice allow. So it might be the case that you make these points and they're just not put before the court, and the court does not consider them. Alternatively, the court may, in the interests of justice and the wider public interest recognised in Taupada, allow argument on these fresh points, but it then may come on to hit the claimants with an adverse costs order further down the line. And importantly, it may hit the claimants with such an order, even if they're successful on these fresh points. So there's a real cost risk and also a broader risk that the arguments are not going to be considered. You then, thirdly, have the point highlighted most recently in the Good Law Project JR at the bottom of this list, where even if as a claimant you make your CPR 54.15 application, the court may still then refuse permission to rely on those fresh points. So in this case, a COVID-19 related procurement JR, Mr. Justice Chamberlain refused permission for the Good Law Project to rely on a new statutory provision, which it hadn't put in its initial statement of facts and grounds. So that really highlights the need to raise every relevant argument at the earliest stage possible. Now, the second type of case, I'll deal with it very briefly, is the type of case which highlights the importance of making applications promptly and as soon as possible. And in this case, GA and the Home Office, another Mr. Justice Chamberlain judgment, the Home Office came in for criticism for applying for an extension of time to file its acknowledgement of service on the day that the AOS was due. And the practical consequences for the Home Office in this case of adopting that course and not making the application as promptly as it could have done was that the judge, considering permission, just did not have regard to any of the Home Office's arguments on permission. The GA judgment also highlights a broader point, and this is that procedural rigour is not just something which claimants need to worry about. It's something that is going to be enforced in relation to defendants too. And that is something which is probably gaining more traction over the last few months, over the last few years. Originally, you're dealing with claimant type situations, but now the court is concerned with defendants following the rules too. So looking at some more robust enforcement of the rules, are there any examples of a more flexible approach, an approach which recognizes the flexibility outlined in Taupada? Yes, there are, and two examples here. The first is a case, Leighton and the Lord Chancellor, and this was a case about the recovery or the decision by the Lord Chancellor regarding the recovery of costs for discrimination claims in the county court. And the Lord Chancellor's overarching defence to the claim was that he hadn't yet made a decision on this point, and so effectively the claim was premature. However, 2 weeks before the substantive hearing, in the Lord Chancellor's skeleton, points regarding ECHR Articles 6 and 14 and some common law arguments were raised for the first time. And the claimant sought to take a pleading point in respect of those arguments. That pleading point was rejected by Mr. Justice Kavanagh, who allowed reliance on the arguments. And he did this for 3 reasons. And I think it's worth setting out those reasons because it shows you how the admin court is likely to afford some degree of flexibility, where there are breaches of the rules or not the most perfect adherence to procedural rigour. So the first was that the case was of general public importance. The second was that the case was going to potentially affect multiple defendants to future discrimination claims. And so the issues had to be ventilated as fully as possible. And I think on both of those points, there's an interesting tension here between the AB case that I referred to a few moments ago and this case, and a question as to whether in reality, and also as a matter of principle, claimants and defendants should be expected to comply with the same levels of procedural rigour But I do think that's probably a broad argument for another day. The third reason given by the court for allowing these arguments was that there wouldn't be any injustice to the claimant because these arguments had grown organically out of the statement of facts, out of the case summarized in the grounds of resistance. They'd been foreshadowed in witness evidence a few months earlier, and they had been dealt with adequately by counsel for the claimant at the oral hearing. Now, of course, this case, Leighton, is to a large extent fact specific, but it is the kind of case that I think defendants in breach of the rules might want to rely on in the future. And it's also a case that claimants might need to try and distinguish where a defendant is in breach. Now, the second example that I want to deal with is a case, Raja and Hussain, a recent judgment of Mr. Justice Fordham. And this was a challenge to a decision not to provide interim care and support under the Care Act. And it was an example of what is referred to as rolling judicial review. So when you've got a challenge to an ongoing failure to do something or an ongoing state of affairs rather than a specific decision in the past. Now, I don't obviously have time to go through this in any detail, but it's worth highlighting the premium that Mr. Justice Fordham places in this judgment on the importance of procedural flexibility and the fact that the admin court will in some cases need to be alive to arguments evolving, to evidence evolving as proceedings go on. And I think there's a really interesting comparison here between Raja and Leighton. Now, obviously they are different beasts in that Raja and Hussain is a rolling judicial review case. So it's slightly different to your standard JR. But I think there is a comparison in that in Leighton, you have an example of procedural flexibility making up for a lack of procedural rigor. And I think it's fair to say in Leighton, the defendant did take a risk in raising these arguments at a fairly late stage and putting themselves at the mercy of the court. In comparison, in Raja, you do seem to have a marriage of procedural flexibility with procedural rigor. And you can see how the kind of approach advocated and championed by Mr. Justice Fordham in Raja will continue to be adopted by the admin court. I think what's less certain, and which will be interesting to watch as months and years go on, is whether the kind of leeway afforded to the defendant in Leighton will be replicated, or whether the growing need to enforce the rules by the admin court will root out that kind of permissiveness, that kind of approach that the court adopted there. That's all I have. Thank you very much for tuning in.
Thank you very much, Will. That was extremely interesting. It seems to me it reflects essentially the way that the public interest in judicial review actually cuts both ways. Because on the one side, you have claimants who may have really acute personal interests at stake, such as a challenge to deportation, but also may in effect represent a much wider category of people who may be affected by some form of public law action. And of course, claims being brought sometimes in less than ideal circumstances, not least because of time pressure. But on the other side, given the importance of the issues, it really is essential that there is some kind of orderly process that allows the court to properly determine the claims. So it's perhaps not surprising that there may be a little gulf between rhetoric and reality in this area. Now, finally, last but not least, the vital question of costs. Azim.
Thanks, Tim. Hello, everyone, and thanks very much for attending today. So it falls to me today to deal with the money, and in the 10 minutes or so, or 12 minutes, I'm going to outline the key issues that arise when dealing with costs in judicial review and how to manage them. So I'll share my screen, hopefully successfully, and see how that works. There we go, and get that started. Right, okay, so recap on the key principles first of all. And this really picks up, I think, with the themes that Will was outlining in his talk a moment ago. So judicial review is not exceptional, it's treated like other civil litigation and therefore falls within the scope of Part 44 and Rule 44.3 2 in particular. The key authority remains the decision in M and Croydon. And that as you may recall, was an appeal concerning an age dispute where the law on age assessments was very much in flux at that time. And the lead judgment was given by Lord Justice Neuberger, as he then was. And he outlined the key principles that are still applicable today in terms of how you deal with costs in judicial review. Firstly, the decision on costs is primarily a matter for the discretion of the trial judge. The general rule applies because judicial review is treated like other civil litigation, namely that the unsuccessful party pays the successful party's costs, and the basis of funding is not relevant. So whether a party is legally aided, publicly funded, acting by way of a pro bono arrangement or by way of a CFA, should generally not be relevant. That said, see the recent decision in the ZN and Afghanistan case, so 2018 Court of Appeal decision, and a judgment of Lord Justice Singh, in which the point is made that it may not be entirely irrelevant that a party is legally aided, and I'll come on to that in due course. Costs after settlement but before trial, and this arises in judicial review on a huge amount, frankly, given the number of judicial review claims that settle. A claimant, this is the proposition in M which Lord Justice Neuberger set down, a claimant who, after complying with the pre-action protocol and issuing proceedings and obtains by consent all of the, I should say, relief he seeks, should, absent good reasons, recover his costs. That's M at 49. And that's the starting proposition. But that was refined by Lord Justice Neuberger in setting out three different categories of cases. Firstly, a case where claimant has been wholly successful in obtaining the relief. Secondly, a case where he has succeeded only in part. And thirdly, a case where there's been some compromise which does not reflect those claims. And if we dig down into that a bit more, what the Court of Appeal, Lord Justice Neuberger, was saying was that in the first case, it's very hard to see why a claimant should not recover all of his costs unless there's some good reason to the contrary. And of course, that reflects the position in Rule 44.32. In the second case, it may be that the court can form a view on the issues, and if so, it can apportion costs, a percentage apportion. But if not, then there's much for saying that there should be no orders to the cost, because the task is frankly too difficult for the court to engage in. And in the third sort of case, again, a court may often be unable to gauge whether there is a successful party, and if so, who that is. And in such cases, there's even more of a powerful argument that the default position should be no orders to costs. But in some cases, as Lord Justice Neuberger outlined, it may well be sensible for the court to look at those underlying claims and inquire who would have won. And that's the point that comes out of the Afghanistan case I made reference to a moment ago, which is that it may be that a claimant who is legally aided can successfully encourage the court to delve into a position which may on the face of it be unclear, because of the significance of a claimant who's legally aided being able to recover their costs. And as we know, the inter partes rates for claimants' lawyers is substantially different to what a claimant's representative can claim by way of legal aid rates. Now, I'll give three examples just very quickly in terms of how Emin Croydon has been applied since 2012. And I go through, if you like, the sort of three chronological examples there. The first is a case which was decided around the time of M, which is the Noreen and Salford case. And that was a case in which the claimants were a married couple from Pakistan. They were asylum seekers, and their claim for asylum was rejected. They instead applied for accommodation and support from the local authority, and the local authority rejected that application. So a claim for judicial review was brought challenging that decision. And in the course of that claim, the court granted interim relief that the local authority provide accommodation support. In the meantime, the claimants were granted exceptional leave to remain by the Home Office, and as a consequence, they did not need to pursue any longer their claims for support against the local authority, but they sought their costs of bringing that claim for judicial review. And the court rejected that application, and that claim was application was rejected again on appeal. And the key point that the court made in rejecting the appeal was that there was a distinction to be had between success in obtaining interim relief and whether the claimants would have been successful ultimately in the action on the claim for judicial review. On that basis, the claim for costs was rejected. The second case is the specialty produce case, which was a commercial judicial review. And that was a case in which the applicant was a fruit and vegetable producer, and it had its necessary status as a producer organisation removed by the Secretary of State, the Department for the Environment. And the applicant challenged that removal in two ways. First, it brought an appeal under its statutory right of appeal, but it also maintained parallel judicial review proceedings on the basis that there had been an abusive process in the decision-making around its status. And the independent panel on the statutory right of appeal made its decision first, not least of all because the Secretary of State had sought to expedite that particular process. And the independent panel recommended that the status of the producer be reinstated, the claim producer be reinstated. As a consequence, the JR had become academic, and the only issue was one of costs. And the claimant sought their costs. That was rejected, and the court, the claimant obviously renewed the matter to the court, and the claimant's position was that the relief that had been sought in the JR had been obtained by way of the statutory appeal, and therefore it was entitled to its costs in both sets of proceedings. That was rejected by the court, which held that the real issue in terms of determining the costs of the JR was who would have won on the abuse of process argument. And that simply could not be determined in the case. Interestingly, the court remarked that the claimant had taken a belt and braces approach and had been prepared to back two horses, but ultimately the horse which did not have good odds came home first, and it could not claim costs of the horse that never came home. That was the basis of its decision in that case. And we've got most recently the decision in the Johnson case, which was a JR that concerned a decision in the way in which universal credit was paid out for certain claimants, and the divisional court held that that process was unlawful. But interestingly, that was a challenge against the benefit scheme, which had succeeded on entirely different bases to the grounds that had been pleaded by the claimants. And the Secretary of State took that point in seeking to resist costs. It accepted that in principle, some costs were payable, but it sought to claim that 50% was the appropriate figure. The divisional court disagreed, and it decided that the fact that the claimants had succeeded on a basis of law not included in their pleaded grounds did not mean it was appropriate to make any reduction in costs. And it rejected the idea that the starting point should be a reduction in costs. Interestingly, that case is now on appeal to the Court of Appeal, so we'll see what that decision holds. The upshot, I think, from all of this, when thinking about tactics, both as a claimant and as a defendant, in respect of seeking costs, is as follows. I think, firstly, one has to think very carefully about what constitutes success in the particular case, because that will be the touchstone for deciding where costs fall. And I think, regardless of which side you're on, one has to look at, well, what is the remedy that was actually sought by the claimant? Was that the main relief sought? And has the claimant obtained that main relief by way of their claim? Secondly, was the pre-action protocol complied with? And if not, why not? And thirdly, and significantly, have there been any intervening factors or acts which have taken place in a situation where a claim has been brought, but the claim has then been settled before a final judgment of the court? And can it be said, if you're claimant, that the intervening act has had no impact on why you obtain the relief that you obtained by way of consent? Or as a defendant, can you say that the real reason why you've consented to a particular form of relief and the end of the claim is not because of the claim, but because of that particular intervening act? And then finally, and this will obviously be fact specific, are there conduct reasons or other such reasons that a party can rely upon, whether you're claimant or defendant, to say that the costs cannot be justified or should be limited? In terms of the process in determining costs, well, that's set out in the Administrative Court Guide and see Annex 5, and I won't go into the details. I've set out the basic propositions there as to the order in which submissions are made and how that process works. I think all I would say is that the procedure is now very streamlined, and woe behold a claimant or defendant who fails to comply with that procedural rigor as set out in the guide. You will see, and I've seen it in cases I've been involved in, consequences as a direct result of not complying with those procedures. So consider those procedures very carefully. Bear in mind, the last point I'll make on procedures, bear in mind that the requirement is to make your submissions on costs within 2 pages of A4, and that if you have to, if you seek to go beyond the 2 pages, that in itself requires an explanation within the submissions as to why the length of the submissions justify extra text. 2 further topics to briefly touch on: costs following refusal of permission. These are now well-established principles, and not a great deal has changed, frankly, since these leading cases. The first is the Ewing case, a 2006 decision of the Court of Appeal, which is to the effect that a defendant can obviously claim their costs of the acknowledgement of service and summary grounds of resistance where permission is refused on the papers. But the important point as a defendant is you must state within your summary grounds the amount that you're seeking, and you must supply a schedule at the time that you're seeking those costs. And if you don't, again, the court may come down very hard and refuse to give costs in those circumstances. And I have seen instances of that happening. If there is a good reason for why a schedule cannot be supplied, then the court should be made aware of that fact, and that should be explained in detail by the defendant at that point. Finally, on permission being refused, the other important decision remains the Mount Cook case, which is that a defendant will generally not be able to obtain the costs of attending a renewed application for permission hearing. There are exceptional reasons where you can persuade a court as a defendant that you are entitled to your costs, and those include the hopelessness of the case being pursued by the claimant, the persistence in which it's being brought, and whether in reality, by way of that renewed hearing, the claimant has had in effect a substantive judicial review hearing. Finally, payments on account. These are very important for either party, and have not been until recently utilised by parties in judicial review, perhaps because parties in judicial review don't think that CPR 44.28 applies to judicial review. But as we saw at the beginning of my talk, judicial review is not an exception to Part 44. That the short point is that a succeeding party can apply for payment on account. This will probably be most significant in commercial judicial reviews, or where a claimant is publicly funded and has succeeded on their claim for judicial review. The point is that the party can obtain a payment on account, and that the rule is to the effect that there's a presumption that one will be made unless there's a good reason not to do so. A good reason does not include the paucity of information put forward by the claiming party as to the cost that they seek, but the court will be very cautious if a payment on account is being sought, but without any information or evidence as to why the figure sought is justified. In terms of the figures, the key point is that it's not the case that the irreducible minimum will be provided by the court by way of a payment on account. What you need to do as the claiming party is set out in some detail what the costs are, how those have been incurred, and why you say that effectively, given that the costs will be subject to assessment, a detailed assessment or settlement in due course, that you are confident that the payment that you're seeking will not be recouped or will not is not an inappropriate amount in all the circumstances. So that's a quick whistle-stop tour through costs. I hope you found that helpful. My slides will be available after the talk. Thank you. Over to you, Tim.
Thank you, Azim. That was both helpful and very interesting. Just reflecting on the Mount Cook principle, it does seem to me that there's a bit of a vicious circle here, because I can see that the reason why the case law discourages defendants turning up for permission hearings is that that does create mini trials, as Azim was really just saying. But on the other hand, given the complexity of judicial review nowadays, they often are mini trials, and the defendant will have quite an acute interest in trying to, if you like, nip the claim in the bud if it properly can. So I must say, for my part, I do wonder whether that really strikes the right balance. Now, it's 1:48. So we've just about kept to time. Thank you very much for those of you who are still with us and still have time, and I'm pleased to see most people are. We do have one question already, but if you have others, please do put them in the Q&A. And the first one is a rather knotty one, and he raises an interesting point, and with it a question, which are that there have been some very important changes to the rules for witness statements in the business and property courts. And of course, they essentially are an attempt to get away from the practice of putting in witness statements, just recite reams and reams of documents, and place a lot more emphasis on the witness's personal knowledge. And Louis asks whether such requirements could be implemented, as he says, with appropriate tweaks in the admin court. And I suspect the tweaks are where the devil lies in this question. But does anyone on the panel want to say anything about this before I might just venture a view? I don't see a forest of hands. Well, if I may, I would have thought change is coming. But on the other hand, the function of a witness statement in judicial review is different. Because of course, once upon a time they were affidavits, but we're still in the position where evidence is generally written and cross-examination is almost unheard of, even though of course available. So I do think for my part that a straight read across of this practice direction and the amended rules would not be appropriate. But I think as Louis' question asks, some flavour of this may well reach us in CPR part 54 sooner rather than later. Does anyone on the panel want to add anything to that? No. Well, let me just ask one question. Will, it's so interesting to know you were inside the administrative court and have the inside scoop. One thing that Imogen touched upon was the practice of people sometimes filing replies at the permission stage. And it's obviously right that the rules don't specifically allow for that. But I have to confess, I do it routinely if there is something to say, as long as it can be done in a way that is short and it can be done quickly. Is that bad? Am I wrong? Does that put me on the naughty step?
So from my experience, no. Every judge that I sat with who was considering permission stage applications would always consider a reply, regardless of whether or not the claimant had put a formal application in. But I know, I've discussed this with Imogen previously, and I know she has a specific view about putting in formal applications. I think the main point here is to try and get that reply in as quickly as possible so that it reaches a judge if they're considering permission, within a few days of the acknowledgement of service. And the other thing, as you say, is to keep it short, and based on what I was saying from the Tau Powder type stuff, don't raise any new arguments.
I'd heard, Tim, a rumour on the grapevine that the issue of replies is going to be formalised later this year. I see Imogen nodding, but someone else on the panel may have more insights.
I'm nodding because I've heard the same rumour, but I think our level of insight might be the same as him.
So I think in the Folks report, they have recommended that there is a formalised right of reply and also formalised right of putting in witness evidence in reply to AOS.
I suspect that any resistance to putting in a formal rule is it will make it inevitable in all cases that a reply will be filed, rather than people, perhaps like me, generally doing it and hoping for the best. Good. Well, thank you all very much to our speakers. As has already been said, the slides will be available on our website. And thank you very much to everyone who found time to join us today. And I hope you enjoy the rest of your day. Bye-bye.